Vehicular homicide, also known as vehicular manslaughter in Florida, involves the killing of a human being caused by the operation of a motor vehicle in a reckless manner, likely to cause death or great bodily harm. The degree of culpability required for vehicular homicide in Florida is less than that necessary to prove manslaughter by culpable negligence, but more than a mere failure to use ordinary care. To constitute vehicular homicide in Florida, the driving must involve reckless conduct, which is defined as driving with a willful or wanton disregard for the safety of persons or property. This means the driver must have knowingly driven the vehicle in such a manner and under such conditions that it was likely to cause death or great bodily harm. Speed alone does not constitute reckless conduct unless it is shown to be grossly excessive. Examples of driving infractions that can constitute vehicular homicide include excessive speed combined with other factors such as erratic maneuvering, driving under the influence of alcohol or drugs, or other grossly negligent acts. For instance, in the case of Luzardo v. State, the court found that driving at 83.9 miles per hour on a straight road in clear weather conditions did not meet the level of recklessness required for vehicular homicide, despite being careless or negligent. However, in other cases, factors such as running a red light while distracted by a cell phone and speeding significantly over the limit have been considered sufficient to establish recklessness. In summary, vehicular homicide in Florida requires proof of reckless driving, which involves a willful or wanton disregard for safety. This can include a combination of excessive speed, erratic driving, and other grossly negligent behaviors that make it likely to cause death or great bodily harm. The penalties for vehicular homicide vary based on specific circumstances, including whether the driver knew or should have known about the accident and failed to provide information or render aid. In Florida, vehicular homicide is classified as a second-degree felony. The penalties for this offense include imprisonment for up to 15 years, a fine of up to $10,000, or both. If the offender leaves the scene of the fatal accident, a hit-and-run homicide, the crime is elevated to a first-degree felony, which carries a more severe penalty. Additionally, the court may order the person convicted of vehicular homicide to serve 120 community service hours in a trauma center or hospital that regularly receives victims of vehicle accidents. The court is also required to revoke the driver's license of the person convicted for a minimum period of 3 years. At Demery Law, we understand the seriousness of vehicular homicide charges. Tanner Demery of Demery Law, PLLC, is a former prosecutor and public defender who has extensive experience both prosecuting and defending vehicular homicide cases through jury trial in South Florida. Tanner Demery skillfully uses his experience and knowledge to zealously represent his clients in order to get great results. If you or someone you know is charged with vehicular homicide, please contact Tanner Demery of Demery Law at 954-224-0577 for help navigating these serious charges. Stay safe out there.